It's great that you could join me today. I want to talk to you about a very interesting topic, and it's regarding the Emergency Act. We now have a public inquiry going on, and we hear people testifying. They're being cross-examined at length. And some of those people are facing criminal charges, or they've already been charged, some of them, I believe, with criminal charges. And the issue is, can what they say at the Emergency Act testimony during their cross-examination, can that be used against them in their criminal proceeding to incriminate them? Well, first of all, the very short answer is no, it can't be used. So if they say something incriminating there's a Charter of Right protection which prevents that self-incrimination, that it can't be used because they're being compelled under subpoena to give evidence against them. Now, you've heard in the States, they'll say, I take the Fifth. In other words, there's the Fifth Amendment where they don't have to testify because it could tend to incriminate them. We don't have that here, but we do have a protection that any incriminating statements they make in any proceeding, let's say you're in a divorce proceeding and you're under oath for discovery about spousal support and you admit that you hit your wife, that can't be used against you in criminal court as to incriminate you. In other words, to prove a criminal offense. But there's a big catch to that. I kind of wish we could take the Fifth here in Canada, because what happens, let's say, well, let's take the Emergency Act, people. Let's say one of those witnesses who's under the Emergency Act is now charged with obstructing police in Ottawa, okay? So they're charged with obstructing police and they testify in their criminal proceeding. Now, how can their testimony be used against them? Can it be used in any way? Well, it can be used in one narrow but important way. So first of all, the Crown Attorney prosecuting them for obstruction, they're going to obtain a transcript of what they said during the public inquiry. And if they take the witness stand in the criminal matter and they say something different on the witness stand in criminal court versus what they said then, the Crown Attorney is going to confront them and say, look, you said you were standing in position A and not obstruction, but here you admitted you were doing something. Now, that goes to, the judge will find that goes to their believability. It doesn't mean the prior transcript becomes evidence against them. What it does mean, it tests their credibility. In other words, they may be a less believable witness, and it offers the judge or jury a chance to reject their evidence because they're not coming across as credible. So the bottom line with previous testimony, like civil testimony, family court testimony, civil proceedings, a public inquiry, it can be used against you in criminal court as a prior inconsistent statement. You've said something different that you're saying on the witness stand today. You're going to get confronted by the Crown Attorney who's going to say, look, you can't keep your story straight, and then the judge might not believe you. So that's the use of previous testimony in other proceedings, and that's going to present an interesting issue for, I'm sure, some of the people charged, because I can tell you this. Even if you're a truthful witness, when you're getting cross-examined by a clever cross-examiner at the public inquiries, it's hard to keep a story straight. It's hard to tell the same truthful version of events the same way every time. That's why I always counsel my clients, look, if you're going to get charged with a criminal offense and the police ask you to give a statement, don't give it, whether you're truthful, whether you're lying, or somewhere in between. You're not prepared. You're going to say something different in that statement than you're going to say on the witness stand. Guaranteed, there's no question about that. And it's going to be used against you to affect your credibility. And in a criminal matter, if you give a statement as well to the police, it can be used to incriminate you. So for example, if the police bring you in and you admit your guilt, well, you've just confessed. Unless you have a way to get that thrown out in court, like a rights to counsel, that's going to ruin your defense. You're not going to have a defense. So the bottom line is, where you can, you should exercise your right to remain silent and never talk to the police. But let's face it, if you're in a public inquiry, it's compelled testimony and you have no choice. So that's what those people are facing. And any type of civil proceeding, you're compelled, and it can be used against you in a narrow sense that I've described here in this video. So I hope that helps you understand how previous proceedings, under oath proceedings, can be used in a narrow way in a criminal case against you. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.